we we have how many rulings we have? How many were there? We have all the rulings ready except 2. So we will start reading them. That would give this chance to just Renaola to read the ones he has.
Thank you, CJ. Because of time, I will summarize the decision, which is by the entire bench. The first ruling is that in the application by the third respondent, to strike out internal correspondences between members of the second respondent. We have said as follows in that application: in view of the issues raised by the parties in their affidavits and submissions, and noting the very limited time this court has to consider and deliver detailed and reasoned decision, and having deliberated on the contested issues before us, our final orders regarding the notice of motion dated 11th November 2017 shall be as follows. The following documents are expunged from the record: the internal memo dated 5th September 2017, the internal memo dated 9th October 2017, the internal memo dated 14th October 2017, internal memo dated 16th October 2017, and the internal memo dated 16th October 2017, and there shall be no orders as to costs. The reasons for this decision shall be given on notice. And that is signed by the 6 judges of this bench. The second ruling is with regard to the application by the third respondent to strike out certain pleadings filed by the petitioners, and these were Volume 1 in the Affidavit of Njonjo Mwe, Volume 2, that is annexure number, Volume 1 of his affidavit, Volume 2, annexure number marked NM21, Volume 9, annexure BA13 in the Affidavit of Billy Atudo, Volume 10A, annexure marked NM21 in the Affidavit of Njonjo Mwe, Volume 10B being an annexure marked BA14 to the Affidavit of Njonjo Mwe, and Volume 12B, annexure marked BA40 to the Affidavit of Billy Atudo. Having looked at the submissions by the parties, and we have given reasons why, we have determined as follows. Prayers A to F, with regard to the striking off of various documents from the affidavits sworn by Njonjo Mwe and Billy Atudo on 5th November 2017, are hereby disallowed. B, the prayers seeking the striking off of the reference to an affidavit by James Gondi at paragraph 76 of the Affidavit on Njonjo Mwe, sworn on 5th November 2017, is hereby allowed. C, as a consequence to order A above, the prayer seeking the striking off paragraph 74, 75, and 30, 31, and 61 of the affidavits of Njonjo Mwe and Billy Atudo are hereby disallowed. There shall be no order as to costs. Signed by the 6 judges of this bench. Thank you, CJ.
The next ruling will be read by Jubilee.
There were 2 applications for interested party by Edwards Kings Onyancha Maina, one in election petition number 2 and the other in election petition number 4. We have considered the application, and by unanimous decision of the court, we find that the applicant does not qualify to be joined as an interested party, and we disallow his application in both petitions. In summary, there is an application for interested party by the Attorney General. We have looked at the application, and upon considering the following arguments by the applicant on the merits of the application, that 1, his application meets the criteria for joinder, that the instant petition raises grave allegations touching directly on the roles played by state and public officers and officers regarding their manner of participation in the fresh presidential election, that some of the issues raised in the petition touching on the conduct of state and public officers were live in cases in which he has represented the national government. We have, having considered those grounds, and by unanimous decision, we find that the application meets the criteria, laid out in the cases of Mumu Matemu and Muruatetu, and therefore the applicant qualifies to be admitted to these proceedings as an interested party. It's signed by all 6 judges.
Thank you, Justice Njoki. Justice Ojwang.
This is petition number 4 of 2017. Upon perusing the application and reading the written submissions in support of the application, and upon considering the 4th respondent's reply to the same, having considered the oral submissions and arguments by a unanimous decision of the court, we find that NASA cannot be sustained as a respondent in this matter. In view of the limited time, the court will give detailed reasons for this decision on notice. Any references to NASA in petition number 4 are expunged from the record of the court and make orders accordingly.
Thank you, Justice Ojwang. The Deputy Chief, CJ.
Thank you, Chief Justice. I have the application by Akuro Alcott, and this is our unanimous ruling that he meets the criteria in Momo Matemo and Muruatetu and is therefore joined as an interested party. Chief Justice, I then have the one for the Jubilee Party that seeks to be joined. The Jubilee Party has applied to be joined as an interested party in petition number 3 of 2017. In the course of hearing that application, counsel for the respondents have raised a preliminary objection challenging the jurisdiction of this court to entertain the petition. Today and for the next 2 to 3 days, this court will be engaged in hearing 2 petitions under Article 140, challenging the election of the Honorable Uhuru Muigai Kenyatta and the Honorable William Samoei Ruto as President and Deputy President of the Republic. Petitions under Article 140 are time-bound litigation, which must be determined within 14 days as required by Clause 3 of that article. This petition does not challenge the election of the President-elect. It is brought under Article 163, Sub-Article 3 of the Constitution. It is therefore not a time-bound petition under Article 140 of the Constitution that we must hear within 14 days. It cannot therefore be heard alongside petition numbers 2 and 4. It is accordingly taken out of the course list of the matters to be heard between today and the 13th of December. We do not even have time to rule on the said application to join Jubilee Party or on the preliminary objection raised by the respondents. In these circumstances, we defer those rulings to a date to be given on notice. Orders accordingly. Thank you.
Thank you, DCJ. The next ruling we have is one by the Honorable the Attorney General to be joined as amicus in petition number, petition number 2. I will read the orders. Having considered the application by unanimous decision of this court, we find that the Honorable Attorney General does not qualify to be admitted as amicus in these proceedings because his application does not meet the threshold set out in the Matemu case. In particular, the Attorney General's amicus brief does not address points of law not already addressed by the parties to this suit, so as to introduce only novel aspects of legal issues in question that aid the development of law. Consequently, we hereby make the following orders under Rule 54 of the Supreme Court rules. Number one, the notice of motion dated 13th November 2017, seeking orders that the court grants leave to the Honorable Attorney General to appear as amicus curiae in these proceedings is hereby denied. We make no order as to costs. The other application, the other matter is this one in petition number 4. In his petition, dated 1st November 2017, Honorable David Kosing, the Member of Parliament for Pokot South, I will hereinafter refer to him as the applicant, seeks 16 declarations. The gravamen of his prayers is that the acts of Raila Amolo Odinga, Stephen Kalonzo Musyoka, Wycliffe Musalia Mudavadi, and Moses Masika Wetangula, together with their political parties, the National Super Alliance, Orange Democratic Movement, Wiper Democratic Movement, Ford Kenya, and Aman National Congress, as well as their supporters, to boycott, sabotage, and frustrate and or obstruct the conduct of the 26th October presidential election amount to treason and an attempt to establish a government in Kenya other than in accordance with the Constitution. Honorable Kosing seeks a further declaration that Honorable Uhuru Muigai Kenyatta was lawfully elected in the fresh presidential election held on the 26th October 2017. On 3rd of November, the Deputy Registrar of this court directed that the petition be served upon all the respondents and that the matter be mentioned before him on 15th of November to determine compliance with those directions before a hearing date is fixed. On 12th of November 2017, the Deputy Registrar took the file to the Honorable the Chief Justice and sought guidance in the matter as Mr. Kibe Mungai, learned counsel for the applicant, was demanding that this petition should be heard before the 17th of November 2017. Upon perusal of the petition, the Honorable the Chief Justice directed that, and I quote, as the Supreme Court is engaged in hearing time-bound petitions under Article 140 of the Constitution, I direct that this petition be heard by the whole court on priority basis after 13th of December 2017, end of quote. Undeterred, the applicant has returned to this court with an application under Section 24 of the Supreme Court Act and Rule 16 of the Supreme Court Rules, seeking that his petition be consolidated and heard together with this petition. We suppose he is referring to petition numbers 2 and 4, filed by Haron Mwau and Njonjo and another, challenging the declaration of Honorable Uhuru Muigai Kenyatta and Honorable William Samoei Ruto, respectively as President and Deputy President-elect. We are this evening going to give directions and commence the hearing of those petitions tomorrow. Honorable Kosing's application cannot be granted for the simple reason that it does not fall within the purview of Article 140 of the Constitution, which requires petitions challenging the election of the president-elect to be filed within 7 days of the declaration of the results of the presidential election and heard and determined within 14 days of filing. Honorable Kosing's petition is not seeking to challenge the declaration of Honorable Uhuru Kenyatta as the president-elect. As we have said, Honorable Kosing's petition is seeking declarations to the effect that the acts of Honorable Raila Odinga, Honorable Kalonzo Musyoka, and their supporters to boycott and attempt to sabotage the conduct of the elections on 26th of October 2017 amounted to treason and an attempt to unconstitutionally establish a government in Kenya. If this court loses focus and succumbs to the pressure and allows all cases by parties aggrieved by the conduct of a presidential election to be heard within the period of 14 days allowed by Article 140, it will be swamped by an avalanche of petitions. It will not be able to determine within that time frame and occasion a constitutional crisis. In the circumstances, we decline to grant this application. We have, as we have stated, Honorable Kosing's petition is not a time-bound litigation. It will therefore be heard with others after this court determines the petitions challenging the election of the president. Those are the orders of the court. The remaining rulings are the ruling seeking the scrutiny, the application by the petitioners in petition number 4, seeking scrutiny. That ruling will be delivered tomorrow. The other ruling is one by Mr. Oganga to be joined in one of the petitions. That one is also not ready, and it will be delivered tomorrow morning. And with that, now we have finalized with the applications, save for the ones which we are going to deliver the rulings tomorrow. And we want to now go to the what? To the pre-trial directions in these matters.
My Lord Chief Justice, in the light of the decision made by this court, then the NASA team would pray to be excused from further proceedings.
Very well. NASA team, and I believe the others whose matters we are not going to hear, you are excused to leave.
You're most obliged, my Lord.
Thank you.